chairman, our distinguished guest, Professor Yusuf Olaolu Ali SAN, we now commence the program. May we respectfully invite Honorable Justice Emi Oredola for the opening prayer. Thank you, my Lord.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار ربنا لا تزغ قلوبنا بعد إذ هديتنا وهب لنا منك رحمة إنك أنت الوهاب ربنا هب لنا من أزواجنا وذرياتنا قرة أعين واجعلنا للمتقين إماما آمين الفاتحة بسم الله الرحمن الرحيم الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا صراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين آمين.
Thank you very much, my Lord. Still part of the introductory session, where we respectfully rise for the national anthem.
Nigeria, we hail thee, our dear native land. Do tribe and tongue may differ, in brotherhood we stand. Nigeria's home, our proud to serve, our sovereign motherland. Our flag shall be a symbol that truth and justice reign in peace. Oh, back to our north in this weak elders' game. To end unto our children, our banner will display. Thank you.
Thank you very much, Joan Jester, with the lovely voice. Thank you very much. Day 2 of the 2025 Annual Criminal Law Review Conference will be discussing extradition, extraordinary rendition, and cross-border justice, legal and human rights implications in Nigeria. As we stated yesterday, this event is being streamed live by up to 150 conferees, most of them were at the Glass House of Kogi State, Government House. We welcome everybody. Before we proceed into the event, we'd like to acknowledge the presence of special dignitaries who have made time out to be here with us today. We want to recognize the presence of Mr. DAUDU, Senior Advocate of Nigeria, the coordinator of Rule of Law Development Foundation. He's the one who is responsible for putting this event together every year, year in, year out. We also want to recognize the presence of our distinguished chairman of the session, Professor Yusuf Olaolu Ali, Senior Advocate of Nigeria, the Kulia Ngeli of the Lorry. Please let's give him a big round of applause. Thank you very much for being here today. We want to recognize the presence of distinguished guests. We want to welcome you, E.C. Ukala, Senior Advocate of Nigeria. We welcome you, sir. Thank you very much for coming, sir. We welcome you. We want to recognize Mr. Paul Harris Ogole, Senior Advocate of Nigeria. Thank you very much for coming. We want to welcome Mr. Adedayo Adedeji, Senior Advocate of Nigeria. We also have all the way from Port Harcourt, Mr. Osima Gina Esquire. Thank you very much for coming. The very next set of guests are special guests who have come all the way from far and wide. We want to welcome the presence of Honorable Justice Emi Oredola, JCA, retired. Thank you very much for coming, sir. We want to welcome the presence of Honorable Justice Jamilu Suleiman, all the way from High Court of Kano State. We welcome you, sir. We want to welcome Honorable Justice Suleiman Abala. Welcome. Thank you for coming. We also have several magistrates from the High Court of Kano State. Yes, my lord. We also have Honorable Justice from Kano State. We have Honorable Justice Haulatu Magaji Kofi. We welcome you, man. We have Honorable Justice Hadiza Abdurrahman. We thank you very much for coming. Conferees all the way from Kano State, thank you very much for coming. We would like to dive straight in. I'm very excited and I can't wait to hear all the goodies we have in store today. We would just like to take a brief profile of all the distinguished guests and discussants. I'd like to call on Mr. ABUJA to handle this session. Thank you very much.
Good morning, everyone. It's under the existing protocol. First of all, I'd like to introduce the chairman of this occasion, who is no other but Malam Yusuf Ali, Senior Advocate of Nigeria. Malam Yusuf Ali, Senior Advocate of Nigeria, is a respected senior advocate. He's a seasoned legal practitioner with vast experience and years of practice in litigation and dispute resolution. He has contributed to the Nigerian jurisprudence immensely. He has represented clients in numerous high-profile cases in various sectors of law, including civil litigation, commercial law, and constitutional matters. The NSU continues to be an influential figure in the Nigerian law. He's an attorney of about 40 years standing. Malam Yusuf Ali SAM attained the highest distinction of legal practice in Nigeria in 1997 when he became a senior advocate of Nigeria. He is the principal partner of the Yusuf Ali & Co. Galip Chambers, a leading law firm in Nigeria and an iconic legal practitioner who is renowned and respected across Nigeria and beyond its shores. Malam Yusuf Ali, Senior Advocate of Nigeria, has delivered more than 200 papers on diverse subjects and topics at various fora within and outside Nigeria. He has published more than 40 articles in learned journals within Nigeria and outside Nigeria. He had contributed more than 20 chapters in books. He is the author of a book titled An Anatomy of Corruption in Nigeria: Issues, Challenges, and Solutions. Please, can we have a resounding round of applause for Malam Yusuf, Senior Advocate of Nigeria. Thank you very much. We also have Mr. E.C. Ukala, Senior Advocate of Nigeria. E.C. Ukala, Senior Advocate of Nigeria, is a distinguished senior advocate with extensive years of experience in legal practice and contributions to Nigerian jurisprudence. He is recognized for his expertise in civil, criminal, constitutional, and commercial litigation. E.C. Ukala, Senior Advocate of Nigeria, is a member of the Board of Trustees and coordinator of the Rule of Law Development Foundation. His desire and drive to ensure that matters are viewed and handled in line with the rule of law makes him highly recommended. E.C. Ukala, Senior Advocate of Nigeria, was a past chairman of the Legal Practitioners Disciplinary Committee. Please, let's make welcome and give a resounding round of applause for Mr. E.C. Ukala, Senior Advocate. We also have Dr. Agada Elachi, Senior Advocate of Nigeria. He's the past president of the ICMC. He's a founding partner and presently the managing partner at Greenfield Chambers. Agada Elachi holds a degree in law from the University of Jos, Plateau State. He attended the Nigerian Law School Buhari and was called to the Nigerian Bar on the 28th of September 1999. He's also a note of the Federal Republic of Nigeria. He holds a doctorate degree in public policy and administration, specializing in terrorism, mediation, and peace from the prestigious Walden University, USA. He also holds a postgraduate degree in peace and conflict studies from the University of Ibadan and is a member of the Society for Peace Studies and Practice. He also holds a master's degree in law from Nasarawa State University, Nasarawa State. Please let's make welcome Mr. Dr. Elachi, Senior Advocate of Nigeria.
Thank you very much. Before I hand over the mic to the chairman, I want to recognize some of our distinguished guests who are watching live from the Glass House of Kogi State. We want to recognize Mrs. Yes, Mr. Abdulhakim Audu, if you can hear me, could you please introduce special guests who are watching us from the glass house of Kogi State?
They keep friendship, the rules of friendship, self-care.
Session manager. Perhaps it's a technical glitch. I have the names anyway. I'll just proceed to recognize them. We have Mrs. Musa Yusuf Falilat, the Solicitor General and Permanent Secretary of Ministry of Justice, Kogi State. Please may we give her a round of applause. We have Mr. S.A. Abbas, the Chairman of the Nigerian Bar Association Lokoja Branch. We have Mr. Ibrahim Ideyi, Director of Citizens' Rights, Kogi State. We have E.A. Idama, the Director of Public Prosecutions, Ministry of Justice, Kogi State. We also have Opanachi Mohammed, Director Legal Drafting, Kogi State. We have Mr. Kamis Yusuf, who is the Director Legal Advisory Services of Kogi State. We have Mr. Atuli Stanley, Director Gender-Based Violence. Please let's give them a round of applause. We have Dr. Abdullahi Wahab Zakari, Director Civil Litigation. We also have Mr. J.O. Ajewole, he's the past chairman of the Nigerian Bar Association Lokoja Branch. We have Mr. Osmo Donoja, he's also a past chairman of the Nigerian Bar Association Kogi State. We have Mr. Olorumola, past secretary MBA. We would hand over the mic to the chairman straight away so that we can comment.
Thank you so much. Let me first of all, before saying anything, apologize profusely for my coming late to this very important event. Those who know me know that I don't play with time, but unfortunately, quite unfortunately, I missed the time of the event, and I had to be called to be reminded, as it were. And then my anxiety to get there, I had to drive myself here. I even missed the way to boot. So I apologize most sincerely. Honestly, it's totally not in my DNA. I don't go late to events. Having said that, I count it as a very great privilege to chair a session where the likes of ECU Kala SAN and the chair Ghana SAN would be speaking to us. And the topic is quite novel. It is new. It is hot. It is current. One of the hottest and most current legal trials going on in our country is the trial of Nnamdi Kanu. And a whole lot of conflict of law principles and international law are involved in that matter. Let me just say that asking ECU Kalaesi to come and talk to a topic like this, in fact, is you know the traditional foreman. There is one foreman who could do the work of 4 people. That's ECU Kala for you. Incidentally, JB himself and I sat together to the glory of God, reinvigorate the activities of the LPDC. JB as chairman and EC and I as members of that august body. And it's quite heartwarming that ECU Kala SN succeeded JB as chairman of that body. All the current jurisprudence about discipline of lawyers in Nigeria, actually with due humility, is due to the very stellar work of the LPDC under JB DAUDU SN's chairmanship. All the landmark cases now that mark the issue of discipline and professional issues in our profession was under his watch as chairman of that body. A torch which ECU Kala SN carried very well as chairman when he succeeded him. So I want to say that our path has come a long way, and I can assure you, EC is already complaining to me about time there, but I've told him you can't say everything today. Let him just whet our appetite, so that other people can also do additional reading of their own, additional researches on this topic. But may I just say, as lawyers, we know the issue of the trial of Kano is sub judice, so we must be very careful the areas in which we touch. Let's deal with the jurisprudence of extradition and other issues, but being very careful not to touch the subject matter of the criminal trial that is going on. If anybody will commit that error, it shouldn't be at a forum organized by DAUDU SA under the Rule of Law Development Foundation. So I want to appeal to all those who will intervene. I know EC very well, he is very scrupulous. He will have avoided anything that will impact on the trial. But others may not be so high to remember that there is an ongoing issue and we must be very careful. I can assure you, I have the 100-page document produced by UTAKO in my hands, but I can tell you for free that they will do justice to this in some 20 minutes. So that, because our time is far well spent, not due to anybody's fault, but my fault, which I accept readily. So you'll be talking to us on extradition, extraordinary rendition, and cross-border justice, judicial attitudes and implications on the fundamental right of fair hearing and personal liberty. These are the core of the guaranteed rights under the Constitution. May I, with pleasure, invite my brother, friend, soulmate, and collaborator. I don't know about conspiracy. We don't conspire, do we? Easy. We collaborate. But JB is a perpetual conspirator. And that's why we say that. So I invite Emmanuel C. Ukala, Senior Advocate of Nigeria, one of the brightest members of the INABA, and one of the most upright that I know, to come and take the podium and do what he knows to do best, to advocate. Easy.
Thank you very much. Thank you very much, my chairman. This feels to me like extraordinary rendition. I say so because from the beginning I pleaded and pleaded that this cross should pass me by. But JB DAUDU, SAN, and his team, and I'm sure with the conspiracy of Malam Yusuf Ali, insisted that I must deliver this paper. First, I was concerned about the fact that the topic is to some extent sub judice, and that it will be very difficult to navigate around it without falling into any of the pitfalls in relation to the rules against discussing matters that are sub judice. But here I am, bound feet and hands and dragged before you. So I present this paper from a place of protest. If it does not meet your standard, as I indeed pray it does not, you understand why it is so. Because even up to 3 a.m. this morning, I was still trying to find my way around it. We had to rephrase the topic a little bit. So when you see what you have on your program, you find that it's not exactly that topic. We had to introduce judicial attitudes and implications on the issue of fundamental rights to fair hearing. This is because we also wanted to shift the focus a little bit from the matter that is before the court. Thank you. The ease of movement that is available with the environment in which we live today is such that it has brought serious issues, which also include the issues of transnational crimes. But most people who are involved in such crimes feel that if they can commit a crime in one country and walk away to another country, they can, under the sovereignty of that other country, remain in that country without being reached by the state in which they committed the crime. So you have people who are sponsoring terrorism in other countries while they are living somewhere else in safe havens, believing that the law cannot reach them. However, to ensure that no offender escapes accountability by merely crossing frontiers, mechanisms for cross-border justice have been put in place. Now, but there is usually a dilemma, because the main mechanism is that of extradition. The dilemma of reach and the dilemma of transfer. If you know that somebody who has committed a crime is holed up or hiding somewhere, how do you reach that person, pick that person from another person's jurisdiction and transfer to your own jurisdiction for purpose of trial? The lawful way provided is through the method of extradition. This is official. It is treaty-based, and it involves the country where the person is hiding handing over the person to the country requiring him for trial. But the process could be cumbersome, as it has all sorts of rules governing it. So there is the other way, which is probably not legal. So we call that the lawless way. So instead of extradition, people or countries can now resort, or do resort sometimes, to extraordinary rendition, which is a forceful secret transfer of a person bypassing treaties, due process of law, and usually this is rationalized by the fact that the countries always say the crime has serious security implications on my country and I cannot ignore it. No matter where the person is, I will find the person and bring him, even if in a diplomatic crate. Now, when an accused person is brought before a court via unlawful rendition, the irregularity of apprehension should that bar the commencement of trial? Should that impact on the nature of the trial the person receives? Does that involve breach of constitutional right to a fair hearing? And can you say that constitutional right to fair hearing is available before trial starts, at the time of arrest, or at the time of seizure? Now, there is jurisdictional, we try to examine the jurisdictional basis for TNC, that is transnational crimes. Now, you have to overcome sovereign limits. International law recognizes principle for asserting criminal jurisdiction. Now, we also have I thought I could do it without my glasses. I didn't realize that I'm that old now. Now, we have different concepts that are in issue. Every state wants to save its own sovereignty. And for that reason, no state wants a situation where crime committed in its own state is left unpunished. So they usually go after the offender, wherever the offender may be. They justify this by saying there are principles of territoriality, there are principles of nationality. Under the principle of nationality, an offender may be a citizen. He is a citizen, and the offender may be prosecuted by his own state for offense he committed abroad. So even where you commit an offense abroad, as long as you are a citizen of a state, the state can reach you and get you punished. Then there is a protective principle, which is that the state's vital security interest will be protected and may answer that jurisdiction, notwithstanding that the acts were committed outside of his territory. Then there is a universal principle, which is that egregious crimes like genocide, war crimes, piracy, terrorism, among others, can be prosecuted on behalf of humanity, no matter where they are committed. So you can see sometimes you see somebody who has committed a crime in Germany against humanity being seized in Israel for trial, or being seized in Pakistan or any other place in the world. That is under this universality principle. Now, but when you follow the method of extradition, then you have to follow the due procedure. Now, in following the due procedure, you can get, the Attorney General is the one that is principally involved with that. And he has to file papers and then serve those papers before request is made, and those requests will be attended to. It also involves judicial activities, all of them put together before you get to the point where a person is either extradited to your country or is extradited out of your own country. Now, there are essential safeguards in the process of extradition, which includes dual criminality principle, which is that the crime that is for which an offender is being sought must be a crime both in the country where he is being sought to be prosecuted, as well as in the country where he is hiding. So if a criminal or a criminally minded person finds that, yes, I can find a country where the offense that I'm to be prosecuted for is not available in that particular country, I hide there, yes, it cannot be reached through extradition. Now, there is also the rule of specialty. The accused can only be tried for specific offenses for which extradition was granted. In other words, once extradition was not granted for a particular offense, you cannot include it when you are trying the person. This was a major argument in the Kano's case, a pillar that was relied upon by the Court of Appeal, to say, as long as you didn't follow the extradition process, bringing him to Nigeria for trial is like bringing him for trial in respect of an offense for which he was not extradited, and therefore you cannot exercise jurisdiction over that. That is a major point that they have at that Court of Appeal level. Then there is a non-refoulement rule, which is surrender must be denied if the person would face torture or cruel treatment. So usually you find that in most countries, when somebody is being sought to be extradited, he will start pleading that, yes, in my country they are known to torture offenders, accused persons. If you surrender me, you are going to surrender me to that torture. And that usually weighs heavily when it comes to extradition. Now, extraordinary rendition is simply the process of, a little bit of taking things into your own hands. You identify where the man normally has his evening drinks, and then you lay ambush for him, you kidnap him, put him in a crate or some other thing, and then walk him across the other country, and then you say, yes, he is here now for his trial. So that is actually extraordinary rendition. Now, it is usually almost like executive lawlessness. But the executive has their own explanation, which is that expediency and national security concerns cannot be circumvented just because you want to, dance to the finesse of or being seen to be upholding the individual rights. I'm sure that those of you who advanced a little bit advanced in age will recall the case of Omar Odiko in 1984 when he was there was an attempt. They almost succeeded. He had been made, I think he had already been put to sleep, and he was enjoying very air-conditioned crates before a very alert officer of the British government noticed what was going on, and that was arrested. So he never really got back to Nigeria for that trial. The recent one is the case of Nnamdi Kanu. All these demonstrate resort to process other than extradition for the purpose of bringing an offender to trial. Now, this would appear to violate the fundamental rights. Rendition definitely violates Section 35, which is personal liberty, and then Section 36, questionably, because the argument will be whether Section 36 kicks in before trial begins, or whether it starts all the way from the time the person is being prepared for trial. Whichever view you take will determine what position you hold. Now, but we say that there is the possibility of breaching the very fundamental principles upon which the international law is founded if rendition, especially when it involves torture or enforced disappearance, is applied, because there's a number of treaties, international laws, and the rest of them that frown against that. Now, we now take a look at the narrow scope of fair hearing in Nigeria, and we have identified the fact that the Nigerian Supreme Court has laid down the jurisprudence that the constitutional right to a fair hearing does not extend to the pre-trial stage. You have cases like Effiong versus the state, Aclrc versus the state, OPDC, which is the most recent Properties Limited versus People of Lagos State. Today is a 1925 decision. Now, so all these show that the right to fair hearing is quite limited. It does not start running from the time the offender is being pursued, which is when it's brought before the court and inside the courtroom. Now, this will actually explain the judicial attitude taken by the Nigerian courts, especially the Supreme Court, because this attitude has been that, look, all these years, our position has been that it does not start until the person is brought before the court for trial. So it is when the person is brought before trial that the right of fundamental, and fair hearing begins. Now, we have cited a number of cases to you there. Now, the implication is that this legally separates the illegal manner of capture from the subsequent judicial process of trial. So you cannot really have a lot of arguments in your favor against the background of this principle if you are simply saying because somebody was wrongly arrested, for that reason the court should not exercise jurisdiction to try the person. They will turn you down and say, no, that's not correct. This is the position we have held over the years. Now, the issue of rule of law. Rule of law is the bedrock of democracy, ensuring that all persons and authorities are bound by and accountable under the law. The ultimate safety against tyranny. We gave you some authorities on that. We have due process. We have the Nigerian judiciary has consistently condemned executive lawlessness. We cited cases like Governor of Lagos State, Juku Friday, Governor of Ondo State, and so on and so forth. So, but I'm not sure that they think that that should impact the issue of how an accused person or an offender is brought to court for trial. In spite of all those you've said in other cases, when it comes to how an offender is brought before them, no matter the method, it is most likely that they're likely to say, you wait until your trial starts before you start having an issue of fair hearing. Now, we tried a comparative analysis of cases from different jurisdictions. We covered quite a few jurisdictions, including South Africa. But we find that basically there are like two lines of thought. You have the Kerr-Frisbee rule developed in Kerr versus Illinois, and Frisbee versus Collins. We cited the cases for you, which is that the important thing is for the person to be brought before the court, and it does not matter how the person is captured and brought before the court. And therefore, the method of bringing the person before the court does not in any way affect either the right of fair hearing, nor does it actually affect the jurisdiction of the court. That is the attitude. This is principally from the line of thinking of the United States, followed almost in majority by so many other jurisdictions. Now the UK had its own, which is the Bennett rule, R versus Horseferry Road Magistrate Court, as parte Bennett. This is a 1994 case, and it's important to note that that decision was long before the 9/11. 9/11 occurred in 2001. Now, the court stayed proceedings in that case, holding that deliberate and egregious executive abuse of process, abduction, must be repudiated to maintain the rule of law. In other words, we have to be very careful how we entertain cases from police or any other person. If they have already breached the law, we bring in somebody before us, we should not honor them. But they went in the later years, in the case of R versus Mohammed, which is 2006, and this was post-2011, 2009, that is post-9/11, where they now said that the court is to rely on substantiality of the charge. And in that case, it was a charge of terrorism and a threat to national security. And therefore, based on that, they held that the accused person should be subjected to trial as the weight of the crime that is alleged against him outweighs the defects in the transfer method. In other words, if the man had stolen 50,000 naira, perhaps you will say the method of rendition is not right. But if it is such a serious crime against humanity, the crime of terrorism and the rest of them, yes, look the other side. As far as we are concerned, the important thing is whether he will receive fair hearing here in this court, not whether he had received it in the hands of the police before being brought before us. Now, so this is it. Then the US also had a method which they says when it shocks the conscience of the people, that is one where you can now intervene and say method of rendition, shock the conscience, and therefore the court cannot exercise its jurisdiction. That probably provides 18 third line. That is the case of US versus Toscanino. We cited it to you there. Now, the Nigerian jurisprudence, well, we have in study of extradition found that, yes, Nigeria is more called upon to extradite its own citizens to other countries. But unfortunately, we have not seen a single case of anybody extradited from outside Nigeria to face trial in Nigeria. None is actually reported that we are aware of, but we'll be happy to learn from here. Now, so this is important, and this probably will inform the decision why we will probably resort more to the crate method. Just send them a crate, and then by the time the crate comes back, if we're able to have a harvest, then we celebrate it. Instead of going through all the paperwork to say, send us the person that is hiding in your country. Now, but in the Nigerian jurisprudence, we first of all have to first look at the Kanu versus Kenya. Kanu sued the government of Kenya for, unlawful removal from Kenya. The judiciary there said yes, they agreed with him, he was right, he should not have been removed, their country was wrong, and they were not impressed by their country's defense, that they were not aware of the method by which he was removed, and that the method by which he was removed was outlawed by their own constitution, and for that reason they found against their government, the government of Kenya. Now, here in Nigeria, he started facing trial and went to the Court of Appeal. The Court of Appeal held, yes, you should not have brought him through the method by which you brought him. It violates his rights, and for that reason, his trial cannot go on, and we will instead order that the court cannot exercise its jurisdiction against him. So that case more or less followed the Bennett rule, which we have referred to, and the rationale is that respect for the rule of law demands that a court cannot allow the state to benefit from its illegal and wrongdoing. In other words, the state must also have clean hands. The court must refuse to act upon such a serious abuse of power to preserve the integrity of the judicial system. So they remember that this is a major issue, integrity of the judicial system. So one should not encourage fighting banditry with banditry. Now, the court also held that by analogy, the spirit of Section 15 of the Extradition Act prohibiting trial for pre-surrender offenses not covered by legal request must apply. That's why I did say that that aspect of what is not covered by the extradition order not being capable of being tried in the court where the person is being taken to is a serious issue that needs to be looked into. So since there is no lawful surrender, the appellant was prohibited from being tried on pre-rendition charges. The lower court was divested of jurisdiction to try the matter on the basis of the rendition. So that is the decision of the Court of Appeal. But then the Supreme Court said that the Court of Trial had jurisdiction, that it is a competition between substantive law and procedural law, and that when the issue is substantive law, you can talk about jurisdiction. But when it is procedural law, you cannot deny the court of jurisdiction. Now, this is quite interesting because when you look at the Extradition Act, you may be tempted to think that it has something to do with substantive law. But no, it is technically a procedure for bringing an accused person who is outside jurisdiction back into jurisdiction for trial. So the big question then will be something that is basically on procedure alone. Is it sufficient to deny a court of law its jurisdiction in the arrangement that we have in Nigeria? Because we are not just common law. We have statutory law. We have constitution. Where does jurisdiction derive from? What defines jurisdiction? So this is what the angle that the Supreme Court came from. They also said, Garba, that national security should be emphasized, and where national security is threatened, courts must be circumspect, and that the security and corporate existence of Nigeria outweighs individual liberties. Now, this year, they were applying then the principle that we call Aclrc principle, because something similar happened there. Now, not that there was no rendition in Aclrc, but the important thing is your fundamental rights. Does it work? It could challenge or displace the issue of national security. The Supreme Court said it does not. Then, international law instruments like Extradition Act or international treaties are merely procedural and cannot, as jurisdiction have dealt with that to some extent. So they also rejected reliance on the Universal Declaration on Human Rights and said all those are not applicable, especially foreign cases. We all know our jurisprudence when it comes to foreign cases. My Lord, the CJN, Aclrc, affirmed that the court was not endorsing the illegality, but held that international treaties do not oust jurisdiction. She also is of the view that remedy for breach lies in separate fundamental rights action. In other words, you can take Nigeria to court, sue them, collect as much compensation as you can, but definitely that will not stop a trial. Now, Salvador GSC also stressed that fundamental rights are not absolute, and that in cases of treasonable felony and terrorism, national security outweighs individual liberties. Agim GSC acknowledged that the government's unlawful and oppressive conduct is unlawful and oppressive, but that under the Nigerian law, such illegality does not nullify the criminal trial, warning that doing so would lead to widespread impunity. In other words, we should not have a situation where, because we are trying to be fashionable in our dressing, we end up exposing the wrong parts of the body. Now, the judicial conundrum, reconciling competing principles. The Nigerian judiciary in cases like FRM versus Kanu faces a fundamental conflict, creating an inherent judicial difficulty. The principle of sovereignty versus the rule of law integrity. If the court dismisses the charges following the UK Bennett rule, it directly upholds the integrity of the rule of law by penalizing executive abuse, but risks undermining the state sovereign rights to punish serious crimes like treason, terrorism, and potentially generating impunity. Now, substantive justice versus procedural justice. If the court upholds jurisdiction following the Care-Frisbee rule, it ensures substantial justice. The trial proceeds, but gives tacit judicial tolerance to executive breach of procedural justice and fundamental rights. That is the act of rendition. Where should we stand? It's all in your hands. Whatever your opinion is my opinion. Now, you will notice that whether we like it or not, public policies shape judicial decisions. The final ruling in this case is not merely a technical reading of law, but a policy decision prioritizing the public good in high-stake security matters. The courts introduce public policy to guide their interpretation and application of constitutional rights. Now, policy of state and prosecution. The policy dictates that states has a paramount obligation to maintain security and ensure serious offenders do not escape justice. Now, this policy influences the objective, compels the courts to adopt narrow interpretation that fair hearing only begins at arraignment. The judicial difference protects the state's paramount interest, insulating the state's power to prosecute from the procedural illegality of arrest. That is, we are applying the principle of Aclrc. Now, you will notice that if you go through most of the cases outside this country, you find that most of them tend to tilt towards saying that, look, what is important is that when the person is brought before the court, that you are able to guarantee fair hearing within that court, but not drag us into how that person was brought before the court, all because they want to protect the sovereignty of the state. Otherwise, it will be so easy for a crime to be committed, somebody walks away, and then it becomes impossible to get the person back. Now, policy upholding the rule of law and due process, the compromise. The courts condemn the executive action as unlawful and oppressive, but direct the victim to seek only civil remedy, damages for rights violation, and under Section 46 of the Constitution. It reminds me of what we have seen in some political matters, where somebody is the one that has won maybe primary election, and then he goes to court, and at a point the court will say, well, yeah, it's true, you may have won, but your political party has decided to feature somebody else. So we, as a court, cannot decide for the political party who to put forward as a candidate. The only right you have, sue your party so that they can pay you damages. So here we're having a situation where, yes, the courts are weighing the fact that, yes, it's illegal, the method, but that's the much we can do. If you want to do any other thing, you go to court by yourself, sue, and then get damages. Now, but this should kind of serve as a deterrent to impunity. The policy choice determines that the greater public threat is criminal impunity. Yeah. And the court reasons that dismissing the trial would only encourage further law enforcement abuses by removing all consequences for the criminal, thus punishing the crime via trial and punishing the rights of violation via compensation. So each person has his own wound to lick. Now, implications for fundamental rights. The narrow definition of fair hearing, of course, means that the scope of enforcement is very much limited. It means that no fair hearing is required until a party is brought before the court, and that being the case, extraordinary rendition cannot seriously be an issue in a Nigerian court. The challenge is maintaining a balance where justice is pursued without compromising constitutional integrity. The focus shifts the onus from challenging the trial's validity to suing the state for compensation, as I've said. Like the remedy obtained by Nnamdi Kanu and the High Court of Kenya, the Nigerian court expects that anybody who is affected should go and sue for compensation, but be ready for your trial. Now, the way forward, perhaps, is the issue of finding the balance. The Nigerian approach is pragmatic, is a kind of pragmatic compromise. And the executive's unlawful act is condemned and punishable via Section 46 of the Constitution, which is you claim civil rights, you claim damages, but the trial itself proceeds to secure accountability for the crime. Our recommendation, however, is that the executive must be encouraged, as the police will say, to be on top of the game. They should be able to find ways of doing things the right way. Let us not just throw in the towel simply because we find that the process could be very complicated. we'll actually earn more respect for ourselves as a people if we follow strictly the rules. Kenya, I understand, is a Commonwealth country. I don't see why a process of extradition could not have been put in place. And if we are a country that has self-respect, I do not see how in anywhere in the world we should not be able to make an official demand to say this person has committed this crime. Let us bring him in. I think we should stay away from reliance on the crates. Thank you very much.
Thank you very much, Mr. Isi Ukala, Senior Advocate of Nigeria. I'm sure we can all attest to the fact that the lead presenter has done substantial justice to the topic, and we will have a lot to discuss during the question and answer session. While his presentation was going on, some dignitaries walked in. I would just like to recognize them. We have Honorable Justice Alaba Ajile, Professor. You're welcome, sir. We have Mr. D.C. Ewelum, Senior Advocate of Nigeria. You're very welcome, sir. We also have Bukola Ajao, who is the Chairman, MBA Banawa Branch, Kaduna. You're very welcome, ma. And finally, we have Musa Yusuf Falilat. She's the Solicitor General and Permanent Secretary, Ministry of Justice, Kogi State. You're welcome, ma. She's representing the Attorney General and Commissioner for Justice of Kogi State. Finally, I would like to recognize one of our panelists who is online, who is going to speak on the topic as well. His name is Mr. Festus Ogun, Esquire. Festus Ogun is a partner at Fo Legal. He's a fast-growing Nigerian firm based in Lagos. He heads the litigation, arbitration, and alternative dispute resolution team of the firm. Festus Ogun is the founder of Campaign for Justice Reform, which is a non-profit advocating for justice system reforms, access to justice, human rights, digital freedom, and sustainable development in Nigeria. Please, can we have a resounding round of applause for him? Thank you.
I'm sure all of us will agree that the lead presenter I think we all agree that Mr. Okada SAN actually filled the bill. Like they say, the taste of the pudding is in the eating. When I was trying to describe him, to introduce him to come to the podium, people might think that I was biased because he's my friend, and so on and so forth. I'm sure. Thank you for giving credibility to what I said about you. Thank you very much. In 55 minutes, you are taking all of us through the labyrinth of a very complicated area of domestic and international law, extradition, extradition, human rights, rule of law, and the decisions of the court, not only in Nigeria. He travels from the US, he came to Kenya, he was in the UK, and he was in South Africa, before he now came and descended on the Nigerian Supreme Court for their own. So I think we want to thank you most sincerely. I've learned a lot from these people and myself. So may I now the contributors, the panelists, you have max 5 minutes going home. Because we want to give the rest of the time to the members of the audience so that it will be more participatory. And that will be the beauty of it all. So I want to call on Dr. Aclrc, Senior Advocate of Nigeria, to please come and...
There's the founder, distinguished ladies and gentlemen, thank you for this opportunity. Mr. Chairman, interesting that my topic is different from our guest topic. And I have also done a paper, though just 15 pages actually. But if you say I have 5 minutes, I really don't know what I'm going to say in 5 minutes. So if I may crave your indulgence to ask for an extension of an additional 5 minutes, just to quickly browse through. And my task this morning is to speak on what protection exists for political refugees and asylum seekers in Nigeria. It's completely different from what my Oga just spoke to. Well, I've introduced the paper, I'm sure will be shared, so I will just speak to it. I've introduced the fact that when you talk about asylum and refugees, you are talking about issues that border on human rights. And of course, it is important to clarify that asylum seekers are different from refugees. Most people think they are the same thing, they are not. I have distinguished that in the paper, and to say that, well, as an organization, as a country, Nigeria has a responsibility, being a state party to various international and regional treaties, to ensure that it upholds the human rights of refugees and asylum seekers when that happens. Now, what international legal framework exists for the enforcement of such rights? There are actually 4 basic of such laws within the international legal framework. They are the Universal Declaration of Human Rights, 1948, and the International Covenant on Civil and Political Rights, 1966. We have the 1951 United Nations Convention relating to the status of refugees and its 1967 protocol. We have the 1969 OAU Convention governing specific aspects of refugee problems. And then, of course, we have the African Charter on Human and People's Rights, which I'm sure we are all very familiar with. Now, of course, what is the effect of our own our domestication of these treaties? By our section 12.1 of the 1999 Constitution, no treaty can apply to Nigeria unless it has been enacted into law by the National Assembly. And our own law, locally, which provides for refugees and dealing with refugees and asylum seekers, I'll talk about shortly. But then what are the legal rights protected by some of these international treaties? Very quickly, the African Charter on Human and People's Rights in Article 4, 5, 6, 9 and 12 talk about the right to freedom of movement and a host of other rights. The 1951 United Nations Convention relating to the status of refugees and its protocol also makes provision for such protections. I'm just trying to skip to it so that I can go to the meat of the matter. In terms of domestic legal framework for protection of political refugees and asylum seekers, it is the law, the extant law today is our National Commissions for Refugees, Migrants, and Internally Displaced Persons Act 2022, which repealed the National Commission for Refugees Act, Cap N21, Laws of the Federation 2004. That is the law that exists today. Now, what are the key highlights from this National Commission for Refugees Act? It is worthy to note that the Act domesticated several treaties which provide for the rights of political refugees and asylum seekers. It is also necessary to make reference to some of these protections afforded therein. And some of these are Section 17, which talks about the principle of non-refoulement. And Baoga spoke about that earlier on. And this section essentially embodies the principle of non-refoulement, which prohibits the returning of refugees to places where their lives, freedom, or physical integrity will be at risk. It provides that refugees cannot be denied entry into Nigeria, expelled or extradited, or otherwise forced back to territories where they face persecution based on either race, religion, nationality, political opinion, or membership of a particular group, and a host of other requirements. It also says that, well, Where the refugee is already lawfully in Nigeria, they cannot be compelled to leave the country unless they have secured asylum elsewhere. This ensures continuity of protection under a durable solution, until a durable solution is found. So essentially, the framework is to provide for preservation of human rights. Section 17 talks about residence pending recognition as a refugee. Section 19 talks about stay of proceedings in respect of illegal entry. Basically what that says is that even if you entered illegally, any actions that should be taken against you ordinarily will not be taken as long as you are enjoying that right. Section 23 talks about protection of family members of the refugee. So if you are a refugee and members of your family have joined you, they also enjoy that protection. And then of course Section 24 talks about the rights and duties of the refugees. Now the refugees also have obligations to the state. The asylum seekers and refugees have obligation to the state that provides them this protection. And lastly, Section 26 talks about assistance to the refugee, and it basically provides an outline of duties of the federal commissioner in supporting refugees' long-term solution and welfare. So all of these are aptly provided for by that law. Now, this is what the law says. These are the legal framework internationally and locally. What is the reality? There has been a steady rise in the influx of refugees and asylum seekers to Nigeria. According to a report of the United Nations Refugee Agency, so 1st September 2025, there exist 142,159,000 refugees and asylum seekers in Nigeria, as opposed to 73,000 in 2021. As such, as of the enactment of the 2022 Act, As such, the enactment of the 2022 Act can rightly be characterized as a timely and comprehensive, particularly with regards to the exposition on the rights and protection it affords political asylum seekers and refugees in Nigeria. Indeed, the Act has provided a robust and favorable legal framework which guarantees the enjoyment of various rights and ensures the well-being, respect, and dignity of political refugees and asylum seekers in Nigeria. However, like most government parastatals and agencies, they are not without challenges. To put it more realistically, the situation in Nigeria, in the Nigerian state, is mostly not the absence of a legal framework, but the absence of proper implementation and the political will to implement the existing legal framework. So even though we have a robust legal framework, we are really not providing that protection. Now, the lack of awareness of the legal framework and the rights of the refugees. So most refugees and asylum seekers, interestingly, also do not have any awareness of these rights. A major challenge confronting political refugees and asylum seekers in Nigeria is the lack of awareness of the existing legal framework governing their protection and corresponding rights accruing to them. Although Nigeria is a signatory to several international and regional instruments on the refugee protection, the practical enjoyment of these rights remain largely illusory for many refugees. As discernible from the legal framework, refugees in Nigeria are entitled to a variety of rights, including the right to adequate housing, access to education, employment opportunities, freedom of movement, access to courts and justice mechanisms. These rights are designed to ensure their protection, dignity, and gradual integration into the society. However, due to the vulnerabilities and precarious circumstances of refugees, such as displacement, poverty, language barriers, and trauma, many are unable to assert or even understand the full scope of these legal rights. And interestingly, my research revealed that there is little or no legal support or legal assistance being offered to this scheme of people. Again, my research reveals an opportunity. So for those of us who may want to look at that area of practice, that may be an opportunity to key into. Many refugees live in constant fear of harassment, deportation, which in turn hinders their ability to seek legal redress or enforce their rights. This systemic lack of information and empowerment effectively silences their voice and perpetuates a cycle of neglect and abuse. Bureaucratic bottlenecks affecting refugees in Nigeria. The bureaucratic bottlenecks constitute one of the major impediments faced by refugees in Nigeria in their quest for protection, documentation, and integration. These challenges often manifest through administrative inefficiencies, procedural delays, institutional inertia within agencies responsible for refugee management. A primary concern is the delay in granting of the refugee status by the National Commission for Refugee, Migrant, and Internally Displaced Persons and other relevant authorities. Refugees and asylum seekers are frequently subjected to prolonged waiting periods before their claims are examined and their status determined. This delay not only heightens their uncertainty and vulnerability, but also hinders their access to essential services such as healthcare, education, employment, and legal protection. The irony of it, yes sir, I'm trying to speed up. The irony of it is that this situation is not unique to Nigeria. It's just that we are worse off here. Even in the United States of America, refugees and asylum seekers have it rough. However, in their own case, they are entitled to a lot of those benefits, housing and all that, they get it. What they do not get most of the time is the fast-track process to ensure that they settle in. These bureaucratic inefficiencies are often aggravated by limited interagency coordination, insufficient funding, which is a major problem, and capacity constraints within the refugee management framework. In summary, bureaucratic bottlenecks such as delays in status determination, sluggish processing of critical documents, and prolonged appeal hearings create formidable obstacles for refugees in Nigeria. Addressing these challenges requires deliberate institutional reform, improved administrative efficiency, digitalization of processes, and stronger collaboration among relevant government agencies, the UNHCR, and civil societies. For instance, it will interest you to note that the Nigerian Custom does not have a robust Immigration Department does not have a robust unit to deal with issues of refugees and asylum seekers. In conclusion, my recommendations, conclusions and recommendations. In conclusion, while Nigeria has made commendable strides in domesticating international refugee protection instruments and establishing institutional frameworks such as the National Commission for Refugee, Migrants, and Internally Displaced Persons, the reality on the ground remains deeply concerning. The gap between the law in the books and the law in practice continues to undermine the very essence of refugee protection. Refugees who should be beneficiaries of Nigeria's humanitarian and legal commitments often find themselves entangled in the bureaucratic inefficiencies, ignorance of rights, and systemic neglect that expose them to further vulnerability and exploitation. I won't build on that. I'm sure you can take the hint. To remedy this and to ensure more humane and human rights and rights-based approach to refugee management in Nigeria, the following recommendations are made. 1. Awareness and legal literacy campaigns. 2. Institutional capacity building, so that we can have, even among lawyers, can have people who understand what to do with refugee rights and how to deal with asylum seekers. 3. Expeditious processing of refugee claims. 4. Provision of legal aid and representation. 5. Enhanced collaboration with international partners. And lastly, community sensitization and integration. Ultimately, the true measure of Nigeria's commitment to refugee protection lies not only in the existence of legal frameworks, but in their practical enforcement and the lived experiences of the political refugees and asylum seekers themselves. Upholding these rights is not merely a legal obligation, but a reflection of Nigeria's historical reputation for hospitality and its constitutional values of human dignity, equality, and justice. I thank you, sir.
Thank you so much. I won't say anything for now. May I, because I'm aware that one of the panelists is about to board a flight. That's Professor Joy Ezelo, S-A-N-O-N, Professor of Public Law, former Commissioner for Gender and Social Development in Enugu State, and now the founder of Women Aid Collective, WACOM. Prof, if you are with us online, please can you please take the floor before you board your flight? We can do in a very garbled form, but we can hear you. Please go on.
Okay, please. I just want to kindly present very much distinguished since the report of Fashion, there is a lot of issues that were happening with the Human Rights Council in Geneva. So the human intervention will also be around the area of respect for human rights, even in the process of extradition. And the issue of mutual legitimacy as a think tank, for which Nigeria also have a legal framework. We know that Nigeria has ratified its core human rights instrument, including the Convention Against Torture, the Civil and Political Rights, and even the one Convention on Enforced Disappearance, amongst others. So it must respect human rights in any process of extradition. We know that when you raise issues on extradition, a lot of issues arise with regard to ratification of international treaties, reforming extradition laws, establishing clear procedures, because there's always a problem in that regard. But then, how do we deal with lack of clear laws and procedures, or using illegal means to extradite instead of going through the whole gamut of extradition, which is one of the major issues in the case of MNK facing trial and Mekano. And I think here we must also respect rule of law, and it's very important that we're having this discussion, and I want to also appreciate the founder of this Rule of Law Foundation, our own Emeritus NBA President, Joseph DAUDU, SAN. Thank you for having this 7th roundtable and for taking issues of national and international importance. Because human rights concern, and if you look at Nigeria record, when it is scrutinized, there is always a problem. Probably maybe that's why they want a shortcut, because if you go to the law court and then you have to follow the human rights standard, which also the last speaker have referred to issue of the principle of non-refoulement, the 1951 Convention, section Article 33, which Nigeria has also ratified. Then maybe they will never make it through a formal process unless it is a country similarly situated. But even at that can never lend voice to breaching the law. There are political consideration issues, definitely, with regard to extradition. There are clear procedures that must be followed, but sometimes you find that our people lack even the capacity. Nigerian legal system faces a lot of issues around resources and capacity challenges. The process can be slow, definitely, bureaucratic process, respectability in extradition. Sometimes you don't have the cooperation you need, but like the lead presenter said, for example, Kenya is part of Commonwealth countries, and then they also have their rules regard to legal mutual assistance, and most of those Commonwealth countries have enacted even domestic laws in compliance with international regulations on mutual legal assistance. That will have been easier. We expect that we will have had cooperation from the government of Kenya rather than just using illegal means to bring MLK back in order to be tried. There is also an issue of conflicting laws and regulations. But for me, looking at the fact that Nigeria has ratified all of the core international instruments, it is my position that they must respect it, that they must comply with it, and that in the cornerstone of that is also the issue of principle of non-refoulement, absolute protection, doing risk assessment, broad application, and then the customary international law around the principle of non-refoulement, even extend to people who didn't ratify it. It is a preemptory norm of international for which no derogation is even permitted. So once someone has been brought in illegally, the question then arises, you leave whether it's guilty of offense charge or whatever, and you deal with that issue. And if it doesn't meet the standard, there can't be any trial that will be found that will meet the standard of rule of law if the court were to proceed. And the court must really intervene to show protection and to show respect and judicial oversight. The court must review extradition requests protecting individual rights. In this case that we were mentioning, there is no request, but again, they have to ensure accountability, investigate and prosecute. How did it come back? There has never been any disclosure with regard to that, and ensure that human rights abuses, the extradition cases are dealt with. So in order to round up, because I have to board my flight, this is a discussion that we must continue. The issue of dual criminality requirement, because in the process to prosecute someone, there are also people have also committed a lot of crimes. Must also be looked into, and then Nigeria should rule of law is very important. It's a cardinal principle of democracy, and that's where, in order to ensure that we don't breach international obligations, because there is state responsibility to respect, to protect, respect, and fulfill international human rights standard, and that must be respected at all times. So, for me, we need to reform a bit of our extradition laws. We need to establish clear procedures. There is need for capacity building of frontline officers involved, and that will include law officers in the Ministry of Justice, prosecutors, and then also, importantly, also judges themselves, because they have to exercise judicial oversight in that. So again, thank you. I am rushing, and I hope in my thoughts is still a bit coherent. I haven't had much time to reflect on this. When the feminist invitation have been really on the move, like I said, and I'm still on the move. So thank you for this opportunity, and I hope we can continue the conversation. Thank you.
Thank you very much. Please, you have said it all. Discussion continues. Thank you very much, Professor Ezelo, SAN. We will now go to our last intervener, Festus Oho. If you are there online, can you please take the floor and make your contributions in not more than 5 minutes. Oh. Mr. O, are you there? It's not. Okay. Now, I think we have enough to chew, actually. As between the lead speaker, the deputy lead speaker, and Professor Ezelo, SAN. So I'm going to throw the floor open, but I want to make an appeal. A lot of people may want to contribute to this. So please drop all preliminaries. Don't comment Ukala. Don't talk about Tolechi. So, just go straight to your point. All protocols have been duly stood upon, if I observed and over-observed. People have been standing on protocol since, so they've killed it. So, don't even worry yourself. There's nothing to stand upon again. So, no, you'll be the, don't worry. I will call you when I feel like. And don't intimidate me with your hand. So, you know, the microphone is very powerful. I tell you. To God be the glory. So please, let's give the floor to some of our colleagues, and then thereafter, if it's question, just go straight to your question and tell us who you are directing the question to. If it's a comment, you can also as well do your comment. Yes, my lord. You are retired. No. Wait. Don't give to people who are retired. Let's talk to people who are still in service. Okay, give it to me, Lord.
Mr. Chairman, even when Mr. Ukala has done a good job, he still insisted we should not commend him. All right. So I'm not commending him, but I'm acknowledging his good work. Having listened to him, one question crossed my mind. And the question is, to what extent really should policy determine cases in court? And my thought about this is that policy should not be the sole determinant for courts to determine cases. because facts will still be presented before them, and they are still required to look into the facts. And therefore, my recommendation is that policy should just be a guide. Policy should be a guide and not the sole determinant. And one thing is, in allowing policy or in applying policy in our cases, there is still the need for us to be aware that the law has to be consistent. The court has to be impartial. The court has to be objective in coming to decisions. So, in applying policy, courts should not allow their decisions, or should not allow people to read political influence into their decisions. That, oh, of course, yes, what do you expect from because of the political nature of that case? So, essentially my submission is, courts should still inject some basic principles of law, like impartiality, objectivity, looking at the facts of the case in coming to decision when applying policy in their cases. Thank you, Mr. Chairman.
I'll also be brief. Chairman, thank you for finally giving me the microphone. My comments and indeed questions go to, eventually, maybe Professor Ezilo SAN is not listening again, but let me go straight to the point. My learned brother Silk, AC Ukala SAN, did draw the distinction, or acknowledge the distinction between substantive and procedure in the decision. I don't know if it was Garba, JSC, in coming to the conclusion that they were not, that the entire gamut of his case hinged on procedures or stems from procedure and not substantive. And that on account of that and other reasons, they were not going to uphold the decision of the Court of Appeal. EC did say that the decision of the Supreme Court, smart or went around the issue of public policy. Public policy, like Prof has said, Justice Agile, has increasingly crept into the judgments of the Supreme Court. In fact, I'll give JSC at a point in time, or in her valedictory speech when she was retiring, described the Supreme Court as a policy court. I've always taken exception to that. They're a court of law and justice bound by their oath to decide according to the correctness of decisions. But they still always insist that there are times that it is expedient for them to adopt a policy so as to achieve a temporary goal. But my question, And this comes in high stakes matters. My brother Isi has given the different dicta or decisions of the justices in the Supreme Court. Saulawa, Agim, Kekere, now CJN, and I can't remember the remaining two. But they've given their various decisions. He carefully avoided giving an opinion on the point. My question to him is, Mr. Okala, if you were sitting on that panel as CJN, what would be your decision? How would you decide this matter? That is the question that I have for you on it. No, I still have two more questions. So that let him be thinking of his lead judgment.
That is if your question is not overruled. As so style.
It's a very friendly question. Now, the issue of encouraging reliance on the crate method. You know, Nigeria started it in 1984 with Morodiko. Actually, he annoyed the military government then, and that was their preferred tactic, since they were never ever going to get the British government to extradite him normally. And he has already raised the point that from all indication, we push our people out at the slightest request. But when we ask, nobody actually answers us. And so it encourages our people. Live from the same America whom we extraordinarily render everybody. Just let them just request. If they ask for me now, I'm sure I'll be in the next available flight outside. The crate method appears, or the bundling out method appears to be preferred. Now, what would his approach be? Would you still condemn Nigeria for adopting that tactics when you have an individual? I'm not going into the sub judice part of his case. An individual who has been sought for in different ways. Let's take the individual that is currently standing trial and was extraordinarily rendered from Kenya. Intelligence report is that he was there for a few days. Apparently, he breezed into town and he presented an opportunity. Would you not think that such rare opportunity to the state will not create an exception to them approaching the extraordinary rendition approach? Because the facts and circumstances are different. You cannot, within those few days while that opportunity arose, ask for extradition from Kenya. So, would there not be extenuating circumstances? That is really the question. That will justify extraordinary rendition. For Dr. Elachi Agada, my question is this. Are you suggesting that we do not have NGOs that provide legal or any other type of support and services for refugees? With the amount of, how do I put it, saturation of our people that we have in non-governmental organizations, are we really saying that nobody has seen? And I see people going to visit IDPs, and they are usually non-governmental organizations. Or are you saying it is the legal business part of it that is lacking? And if it's the legal business part of it, have you factored in who will pay the lawyer's fees? Is it the refugee who can barely eat? or feed and does not know where his next meal is coming from, how is it an attractive field of law, except it will be pro bono for young lawyers? And then another question for young lawyers, they have the energy and it will boost the application for SA. Now, another important part of this is yes, you did say about the NGOs. Now, the statistics you offered as to the population of refugees in Nigeria, I am just interested in knowing whether the statistics take into account the dichotomy between internal displaced persons who are also refugees and refugees who come in, say, from places like the Sudan, from areas where there is war. Like some people came in from the Bakassi at a point in time. The figures you gave, does it take into account this dichotomy between internally and externally? And what difference, if any, is government approach to the two categories of refugees? That's the question for you. Now for Professor Ezilo. Yes, she has gone, but I think EC she dwelt on EC's topic, and it does come. I understand from Professor Ezilo's submissions that she's completely against the manner in which Nnamdi Kanu was rendered into Nigeria. And that her position is that regardless of public policy, regardless of the substantive or the substantiality of the offense, which in this case is street treason, regardless of all those other factors, what should trump the matter, not Donald Trump, the decision of what should be paramount in the minds of our courts is the fact of the initial illegality, and that it should affect every other step going forward. But so the question is this. I do not agree, or no, my view before I ask the question, I do not agree that this position of the Supreme Court is based on public policy. I do not think so. Their decisions have been consistent. Starting, if you remember these cases of Sadao of Kunya against the state, where the confessional statement extracted was ruled as inadmissible. But then, the contents or the things that showed that Sadao committed the offense of murder were extracted from the confessional statement, where he buried the weapon and other exhibits which led to his guilt. In the US, the result would have been that all the evidence, where illegally obtained, goes to no issue, and the one will be discharged and acquitted. The Nigerian courts, particularly our Supreme Court, and I have suffered a victim of such decisions in my forays into criminal appeals before them, where the underlying basic evidence is inadmissible, but they upheld the conviction on the basis of illegally admissible evidence. So that is indeed the basis of their decisions in these cases, which is that it doesn't matter the illegality of the event, of what prompted it, but that the entire exercise will be viewed on the basis of the charge So that's just my observation. If you can help Professor Easily out on that point.
Please let the microphone go to the man who has a list of the problems. Can I say? It's just one salvo. Okay. So answer JB, then you come to the man.
Okay. Thank you, sir. Thank you, Chairman. My leader, I think the answer is quite straightforward. My focus is on the area of the legal aspect of the NGOs. Yeah, NGOs who exist, but all they are doing is maybe share bag of rice and so on and so forth. And there are none that provide that legal service. I've actually, at least none that I was able to find out. Let me use that phrase. Maybe they exist, but the activities are either not publicized or it's not loud enough for us to have been able to keep track of it. How will they, if I encourage people to take, how will they get paid? Well, the first point, as you said, rightly said, is that I know a lot of people who inundate yourself, several of other seniors and myself. Now, some of us with, I need cases that I can do to go to take upstairs. These are a very good pool of cases you can get. But my experience, and if I may piggyback on the fact that this foundation exists at the moment, is that where there is a need, there is always a way out of it. If we, and those who are interested, conceptualize, this is not an area of practice I'm interested in, but if somebody was interested in this, they could frame it in such a way that I am sure and certain that they will find international funding. At least I know I have the privilege of consulting for the ECOWAS in a number of areas, especially in the areas of conflict resolution. And I know that they have a department that works on this. And if somebody was to take this up and design it properly and demonstrate the workability, I'm sure that you'll be able to find funding. That would be my answer in that respect, sir. With regards to the statistics that I made reference to, the statistics are limited to those who came into the country, those who are coming into the country, and not internally displaced persons. Yes. And as you asked, if in the realm of government there is a distinction, yes, sir, there is a distinction. As far as our government is concerned, the internally displaced persons are not refugees in the context of the definition of the Refugees Act and the international instruments. They are simply what they are, internally displaced persons, IDPs. The refugees and asylum seekers are the ones who enjoy that benefit. But if I may just add as a final comment, it's my humble view that the statistic is wrong and that statistic cannot be accurate. But again, experience in Nigeria shows that we are not very keen on statistics. And because our borders are very porous, it's also not easy to track some of these things. So that, I hope those answers are satisfactory, sir. Thank you very much.
Thank you very much, Mr. Chairman. I'm particularly pleased that you put on record the wickedness of my learned friend and brother, J.B. DAUDU. He always singles me out for punishment. Well, I will try. Now let me start with my Lord Justice Ajule on the issue of public policy, which also was part of the decision of the Supreme Court. I would want us to understand the public policy as the public's policy of protection or upholding of the integrity of the sovereignty of the nation. This is all about the sovereignty of a nation. It is basic principle that in respect of that sovereignty, every state should be able to punish, prosecute, and punish for crimes committed within the state or committed against the state. When the state is not able to do so, the state has lost a vital aspect of its sovereignty. So that is usually the base from which all the other arguments take off. And then if you remember when I discussed cross-border justice, the principles of cross-border justice I also laid out, which included territoriality, which means that crimes committed within a state, in respect of such crimes, the state can prosecute the offender for the crime committed within its borders, regardless of offender's nationality. You can't run into my country, commit a crime, and want to walk away because you are not from my country. It is all part of that issue of upholding the sovereignty of the nation. And then the other principle that is important there is the principle of what we call protective principle, which is that acts that threaten the state's vital or security interest are acts for which that particular state is entitled to apprehend the offender and then prosecute the offender. So when you look at all the decisions that are in favor of trying people who have been, subjected to extraordinary rendition, you find that the basis of those decisions are planted in the issue of sovereignty of the nation, the integrity of the security of the nation. This is not something any nation plays with. Therefore, the courts cannot think outside of that. A court cannot say, I'm a court in Nigeria and I don't want to uphold the sovereignty of my nation, or I do not want to uphold the sovereignty of the very basis of our existence as a nation, or something that challenges our nation as a whole. So that is what has informed most of the decisions. There is hardly any country in the world that has taken the view that we can throw away all this and then just focus on individual rights. Because they feel that when an individual is involved, there could be a remedy. That remedy could lie in compensation. But when it goes to the root of the existence of a state, it is a very serious matter. So whether we want to acknowledge it or not, no judge, no court who actually understands it will go out of its way to say, I ignore these basic requirements and therefore go and do. Whether you call it public policy in the way we normally understand public policy, or you call it any other name, it doesn't matter. The central point here is sovereignty. Now, my brother asked me a question. If I were sitting on that panel, what would I have determined? By the grace of God, I was not sitting in that panel. And by the special grace of God, I will never sit as a justice of the Supreme Court. So, am I free to go? So, at the appropriate time, when you see those who decided, ask them. But what we have tried to do is to explain the basis. There is a basis for all this. In all the cases reviewed, virtually every country, you find that what they are doing is, when it comes to the issue of national security, when it is such serious matters as terrorism and the rest of them, no country wants to joke with that. So I think I can rest that one there. Now, he said whether I would condemn Nigeria for adopting the crate method at a point. Or incidentally, there is, this time around, I don't think it was a crate. Nobody told us how they did what they did. And I believe that, was it the same person that was in charge under the 1984, was it? That utilized the crate that was able to see Nnamdi Kanu into the country. I do not remember. But the important thing is, you know, the intelligence, as you said, shows that there was going to be a short stay. The understanding that I have of criminal law is that time does not run against the state. There were people who were involved in the Holocaust in Germany several years ago that have only recently been hunted down and charged to court. There was also, I think, the Brazilian who stole some money, then ran away to some safe island and then stayed there for years, and then after, was it Brazilian? No, I think somebody who robbed the train, ran away to somewhere, whether it was Brazil, yes, Argentina, stayed until maybe the money ran out, and then he decided to submit himself for trial, or he could have been charged at that time. So time does not run against the state. It's not an excuse to say because somebody is going to stay for a short period of time. If our intelligence is also working effectively, we should even be able to anticipate that that person will be in so and so place within this period of time. And then you start the process even before he arrives. As soon as he arrives, then you go on. I do not think that there is any serious excuse for us not trying to follow the law which we accepted and which we made for ourselves. The only way we will gain self-respect is to ensure that we follow the law. That is how a country gains self-respect. And that is perhaps the reason why nobody really talks to us. When we want anybody to be extradited to Nigeria, it's like, oh, this paper is coming from this country. All right, keep it there. Nobody is taking it seriously. But if United States says, I want to extradite somebody from your country, everybody starts running around. Because if you don't, you know that there could be consequences. So we should start doing things in such a way that the world will take us more seriously. Now, somebody said something about, oh yeah, you said pro bono for the young lawyers. I want to inform you that I still do pro bono. And I don't think I'm that young. Yes. Now, Professor Ezilo is completely against extraordinary rendition. The fact of initial illegality should render the process non-cognizable before the court. Yes, the pro-rights person will usually take that attitude. But in my course of years in practice, I have had occasion severally to enlighten my colleagues, my junior colleagues, that when you get into law, you discover that law has depth. And it is the person who is able to get to the deepest part of the law and do his plumbing activities. That is the man who makes a difference in the legal circle. It's so easy to look at these things in a prima facie way and then declare a resolution, a decision. But all the cases that have been reviewed, you will find that they have depth in jurisprudence, and you can hardly fault them. Nobody can say simply because of, procedure procedure then should override substantive law. What gives jurisdiction in our country is the Constitution, is statutory provisions, definitely not rules of court, definitely not laws of such a nature that will be regarded as procedural laws. And that is the point that the Supreme Court is making. These are procedural laws. How to arrest somebody is like saying, okay, because Police Act is breached in the arrest or search, you cited the case rightly of saying, okay, how evidence is obtained is not the problem of anybody. The important thing is that the evidence is in court, it should be tendered. So we cannot say because a person was wrongly arrested, a police officer who goes out of his way to do what he should not do. Instead of arresting without touching, you go there, you arrest, and then you push. And then the person goes to court, raises his hand and says, oh, when he arrested me, he pushed me. And that is against the Police Act. That being so, the trial cannot go on. The court should decline jurisdiction. No, that is not our law. And that is what the Supreme Court has pronounced in Kanu's case. And it's along a long line of cases. So I'm sorry that I do not completely agree with Professor Ezilo on this. It doesn't render the process illegal. Thank you very much.
I think we should do better for now. I think for those of us, if you could remember, in Okonkwo and Nash, the lead speaker is still having a conference. Thank you. In Okonkwo and Nash, Nigerian criminal law, if you remember, there was this case when we were at 300 level that we were taught that you went to search for something in somebody's house. You now found something that was not part of the warrant. The question was, can you try for the what you found that was illegal or not? So if you take off from that pedestal, you can support the position of the lead speaker till tomorrow on this matter. Because I mean, if you can do that domestically, you came to somebody's house to look for him in their hand, and you now found guns. We did not stand logic on its head to now say you can't try him for finding gun with him because you only went there with a warrant for in their hand. So if that can happen domestically, so what's the big deal about it on international law? I don't think so. I'm just trying to read it. I've been thinking about it. I think Semidele or something. One I've forgotten now. It was in 1979 that they taught us. So for me, I think law is about extrapolation. So what happens there, can you extend it to there as long as it's logical? Now let me just quote something. Because this issue of public policy, I know, and I still teach jurisprudence in 4 years. So and I still remember clearly that in jurisprudence we all agree that public policy, that actually all the highest court of the world, at least in the Commonwealth and common law countries, that they are actually policy courts. So it's not an aberration. And you don't need to go too far. However, against Shagari was a policy decision. The decision was between, okay, upholding to what is taught to us of 19 states, or the military will remain. For those who are holding up there. So it's always been part of jurisprudence that the highest court of any country is a court of policy. Because you can't allow this, when you have the society, you start to talk about rights. Once there is anarchy, is everybody for himself? God for us all. Ungoverned space is the most dangerous space in the world. And ungoverned space is the most dangerous. And that is what is happening about banditry. All those places are not properly governed. That's why they take over in those places. So I want to, now let me quote what I found. Public policy is the underlying principle that government actions and judicial decisions should align with the fundamental values, interests, and security of a society. It acts as a standard to interpret and sometimes invalidate laws or contracts that are deemed harmful to the public good, and it can be a source of both domestic and rules for international conflicts. And it goes on and on and on. Even in international law, all the whole idea of international criminal court is a policy issue. Don't waste your time about it. And why is it that the advanced countries refuse to subject themselves to the ICC, but only the third world countries are there? It's also a matter of policy. So for me, I think the whole concept, and the Yorubas have something that looks like it. I'm sure it will be applicable in all the Nigerian languages as well. That Karo Somoti, Karo Dimaso, Kidiomatic Bofu. That is, you either use your line, your tie dress to your lower part, or you tie the body to the dress. The important thing is that not to expose what should not be exposed. So the important thing is that if somebody and you see, I think all these offenses of terrorism and banditry, they are so grievous and grave that and like the speaker rightly said, you cannot subject the right of the society to the right of an individual. There will be no society. And if there is no society, that's the end of story. So I quite believe that. I want to, on behalf of all of you, before the compare will come and do the formal things, I think, speaking for myself, I've gained quite a lot today from these presentations. Because these are areas of law that you interact with on a daily basis. You are concerned with other things, especially people like JB. Commercial practice where big money will come, nobody will know that money has come into the office. You know? These are the kind of things. So for me, it's a good learning that we have been exposed to this. And one should not be surprised. And like I said yesterday, right from its inception 7 years ago, so I should know better. That I can't come here and go home poorer intellectually than the way I came here. So if that also applies to you, please, Chondros clap for the presenter. Sometimes, you know what I call it? Caterpillar clapping. Bam. Thank you. Thank you. Once again, I also want to thank the organizers for deeming it fit to invite some of us here. And like I said at the beginning, I apologize for coming late, but the end has justified the means. That time gave EC UTAKO enough time to boot properly from his sleep. So he was fully awake when I came here. Thank you very much. May God bless all of us.
Thank you very much, sir. I am aware that the Kaduna, the Lokoja branch have something to say. Okay. Thank you very much, sir. I want to say a big thank you to all the resource persons and all the participants. After this session, we will have a 45-minute tea break before the next session. Thank you very much, everybody, and God bless you all. Thank you.
One love, one love, one love, ooh, one love, bring us all together. Ooh, one love, bring us all together. One love, one love, one love, ooh, one love, bring us Thank you very much. It's one love always. Respect.